What if I told you that 10 of America's biggest gun laws just changed quietly right after a shocking November court ruling that nobody saw coming? What if I told you that some of these new interpretations could make millions of responsible gun owners suddenly non-compliant overnight, while others could strip power away from federal agencies that have controlled firearm regulations for decades? Sounds unbelievable, right? But it's happening right now. In this video, we're diving deep into 10 massive shifts in gun laws and enforcement that are shaking the entire nation, sparking fierce debates in Congress, confusion in the states, and outrage across the gun community. From background check overhauls and permit redefinitions, to federal-state conflicts over red flag laws and even new interpretations of what counts as a regulated weapon, everything you thought you knew about the Second Amendment landscape is changing before your eyes. And this isn't just about politics, it's about your rights, your safety, and the government's growing reach into personal freedom. So if you believe in the Constitution, or even if you're just trying to understand what the heck is going on, you cannot afford to miss what's coming next. Because in the final minutes of this video, I'll reveal the most shocking change of all, one that could redefine what it means to legally own a firearm in America forever. So before we jump in, make sure to hit that subscribe button right now and smash the like button so this video reaches every gun owner who needs to know the truth. And as we go through these 10 massive changes, comment below and tell me which one shocked you the most. I really want to see how many people are actually aware of how deep this goes. Get ready, because what you're about to hear isn't speculation, it's real, backed by new legal interpretations, federal memos, and state-level reactions following the November ruling that's already being called the most consequential gun rights decision of the decade. Stay tuned until the very end, because the last revelation will absolutely leave you questioning how much freedom we really have left. 1. Ghost gun rules tightened and now enforceable nationwide. The story behind the ghost gun rules being tightened and now enforceable nationwide is one of the most significant and controversial moments in recent firearm regulation. After years of debate, lawsuits, and conflicting rulings, the Supreme Court effectively allowed the Biden administration's 2022 ATF frame or receiver rule to stand, which redefines what counts as a firearm under federal law. This rule closes what authorities called the ghost gun loophole by ensuring that unfinished gun kits, 3D printed receivers, and parts sold in easy-to-assemble form are legally treated the same as fully manufactured guns. That means these kits now require serial numbers, background checks for buyers, and that sellers must hold a federal firearms license, FFL, to distribute them. Before this ruling, many individuals were ordering parts online and assembling functional firearms at home without serial numbers or registration, making them untraceable to law enforcement. The court's recent reaffirmation of the ATF's power to regulate these kits has created a massive shift in how hobbyists, gunsmiths, and collectors operate. While the Supreme Court's temporary injunction in 2023 had left things uncertain, the latest developments now make these restrictions nationwide and enforceable, meaning local jurisdictions must comply even if their previous state laws were more relaxed. Supporters of the decision argue it's a vital step to stop untraceable weapons from falling into the wrong hands, pointing to rising recoveries of ghost guns in violent crimes across major U.S. cities. On the other hand, critics, including many Second Amendment advocates and gun rights organizations, see it as government overreach and an unconstitutional expansion of ATF authority. They claim the rule blurs the line between parts and finished weapons, unfairly targeting law-abiding citizens who simply build firearms for personal use. Despite the legal outcry, as of now the rule is being enforced, with the ATF issuing new compliance notices and updates to FFL dealers across the country. For gun owners, this means paying closer attention to how and where they buy unfinished parts, and ensuring they follow federal serialization and record-keeping requirements. The new nationwide enforcement marks a turning point not just for regulators, but for every gun enthusiast in America, showing how the federal government is increasingly treating digital manufacturing and home assembly as part of mainstream firearms law. 2. Ammunition background check schemes face big circuit fights and selective rollbacks. The issue of ammunition background check schemes facing big circuit fights and selective rollbacks has become one of the most heated and confusing topics for gun owners across the country. It all started when several states, led by California and New York, introduced laws requiring background checks not just for firearm purchases, but also for every box of ammunition sold. These laws were designed to prevent people who are legally prohibited from owning guns from buying ammunition, effectively closing what lawmakers saw as a loophole in enforcement. However, after recent court challenges and the latest November rulings, those laws are now under heavy judicial scrutiny and in some cases, temporarily blocked. In particular, the Ninth Circuit Court of Appeals recently cast serious doubt on the constitutionality of California's ammo check system, arguing that it may place an undue burden on lawful gun owners without a clear historical precedent under the Second Amendment. That decision, alongside similar challenges in the Fifth and Second Circuits, has created a patchwork situation where some states are still enforcing strict ammo checks while others have had their rules paused or struck down pending appeal. This means that for now, a gun owner in one state might be able to walk into a store and buy ammunition freely, while someone just across the border still faces ID verification, background screenings, or even purchase permits for each transaction. Supporters of these background check schemes say they are a common-sense safeguard to stop dangerous individuals from stockpiling ammunition and committing violent crimes, while opponents argue that the laws do little to stop criminals and instead inconvenience millions of law-abiding citizens. In addition, there have been widespread reports of database mismatches, transaction delays, and false denials, which have angered many responsible gun owners who suddenly found themselves unable to buy ammunition they had been purchasing for years. The court's growing skepticism toward these laws reflects the new legal standard shaped by the Supreme Court's Bruen decision, which requires gun regulations to be consistent with the historical tradition of firearm regulation in America. Because there is no meaningful historical precedent for ammo purchase screening in early U.S. law, judges are increasingly questioning whether these modern schemes can survive constitutional scrutiny. For gun owners, the takeaway is clear: ammo laws are changing rapidly, and what's legal in your state today could be suspended tomorrow depending on how the courts rule next. It's a dramatic moment for the firearms community, as ammunition, once the least controversial part of gun ownership, has now become a central battlefield in the national Second Amendment debate. 3. Waiting periods are being enjoined in multiple circuits. The growing trend of waiting periods being enjoined in multiple circuits marks one of the biggest turning points in how courts are reshaping firearm purchase laws after the latest wave of Second Amendment rulings. Traditionally, waiting periods typically ranging from 3 to 14 days were designed to act as a cooling-off period, supposedly giving potential buyers time to reconsider impulsive decisions and allowing background checks to be processed thoroughly before a firearm is handed over. However, recent federal court decisions, especially those in the Fifth, Sixth, and Ninth Circuits, have begun questioning the constitutionality of these mandatory delays, arguing that they may not align with the historical framework of the Second Amendment as outlined in the Supreme Court's Bruen decision. Judges have started to issue injunctions, legal orders pausing enforcement against certain state-level waiting period laws, reasoning that the government has failed to demonstrate a comparable historical precedent for restricting immediate firearm possession after a lawful purchase. In states like California and Illinois, ongoing lawsuits have challenged the necessity of waiting periods for repeat buyers or concealed carry permit holders, claiming that people who already passed background checks shouldn't be forced to wait again. This has created a ripple effect across the country. Some courts have temporarily suspended waiting period laws, while others continue to uphold them, leaving gun owners confused about whether they can take their new firearm home the same day or must still wait several days. Supporters of waiting periods argue that they prevent impulsive acts of violence or suicide and give authorities extra time to detect potential disqualifying factors in background checks, but opponents counter that these laws unfairly punish law-abiding citizens who have already passed all federal requirements and proven their responsibility. The court's growing skepticism is rooted in the idea that modern waiting periods lack an equivalent in early American history, where citizens could purchase and possess arms immediately without government delay. As a result, the legal trend is moving toward stricter scrutiny of these policies, forcing states to justify them with concrete historical analogs rather than emotional or speculative arguments. For gun owners, this means the rules are changing fast. What was once a fixed waiting period could soon vanish depending on the outcome of these appellate cases. In practice, some firearm stores in affected jurisdictions are already updating their policies, allowing same-day transfers when injunctions apply. This ongoing judicial tug-of-war highlights how deeply the Bruen decision continues to reshape the entire landscape of gun regulation, and it signals a future where waiting periods may become far less common or even unconstitutional nationwide. 4. Red flag/ERPO programs remain legal but are being narrowed and expanded at the state level. The situation surrounding Red Flag or Extreme Risk Protection Order (ERPO) programs is one of the most complex and fast-evolving aspects of America's current gun law landscape. These laws allow courts to temporarily remove firearms from individuals who are deemed a risk to themselves or others, often after a family member, law enforcement officer, or even a medical professional files a petition. For years, Red Flag laws have been presented as a balanced solution, a way to prevent suicides and mass shootings without permanently stripping anyone of their Second Amendment rights. However, after recent court rulings and legislative changes that followed the November decisions, the reality is far more complicated. While red flag programs remain legal nationwide, their scope, procedures, and safeguards are being rapidly reshaped at the state level. Some states, like Florida and Colorado, have expanded their ERPO laws to include broader categories of petitioners and longer removal periods, citing public safety concerns. Others, like Missouri and Oklahoma, have gone in the opposite direction, tightening or outright rejecting red flag proposals, arguing that these laws risk violating due process and can be abused for political or personal reasons. In states where ERPOs are active, new judicial rulings are forcing lawmakers to refine the process. For example, requiring faster hearings, clearer standards of evidence, and penalties for false or malicious petitions. This movement toward procedural tightening came after several high-profile cases in which individuals had their firearms seized without proper notice or timely appeal, raising constitutional questions about the right to a fair hearing. At the same time, the federal government continues to encourage the adoption of red flag laws through funding incentives and Department of Justice grants, creating tension between states that see these laws as life-saving and others that view them as unconstitutional federal overreach. Courts, too, are split. Some judges uphold ERPOs as consistent with long-standing dangerous person restrictions recognized in past rulings, while others argue that, under the Supreme Court's Bruin framework, these laws lack clear historical precedent and therefore face serious constitutional challenges. The result is a patchwork nation. In one state, police can swiftly seize weapons based on a family petition, while in another, no such mechanism exists at all. For gun owners, this means understanding their local ERPO procedures has never been more critical, as crossing a state line could completely change their rights and responsibilities. Supporters of ERPOs emphasize that when implemented fairly, they can save lives and prevent tragedies, while critics stress the risk of guilty until proven innocent treatment and the erosion of fundamental liberties. As both sides continue to clash in legislatures and courts, red flag laws remain one of the most polarizing battlegrounds in the fight between public safety and individual rights, a conflict that will likely define the next phase of America's Second Amendment debate. 5. Permit-to-purchase and permit-based schemes are under direct attack. The growing controversy over permit-to-purchase and permit-based schemes being under direct attack has become one of the most important legal fights in the wake of recent court rulings that have reshaped the interpretation of the Second Amendment. For decades, states like Massachusetts, Connecticut, North Carolina, and Illinois have required gun buyers to obtain special purchase permits or firearm owner identification cards before being allowed to buy a gun, even after passing a federal background check. These permits often involve extra fingerprinting, local law enforcement approval, fees, and waiting periods, all justified by lawmakers as measures to ensure public safety. But after the Supreme Court's Bruin decision and a series of powerful lower court rulings in November, these permit systems are being directly challenged for potentially violating constitutional rights. Judges are now questioning whether states have any historical precedent for requiring citizens to seek government permission before purchasing a firearm, especially when the federal NICS background check system already serves as a nationwide safeguard. In some circuits, lawsuits backed by gun rights groups like the Firearms Policy Coalition and Gun Owners of America have already resulted in injunctions pausing the enforcement of certain local permitting laws, claiming they unfairly target law-abiding citizens and create unequal access to firearms based on location and bureaucratic discretion. In states like North Carolina, where the sheriff-issued pistol purchase permit was repealed earlier this year, lawmakers cited not only redundancy with federal systems but also concerns that local officials could abuse their discretion by denying permits without clear reasons. Meanwhile, in states like Connecticut and Massachusetts, where strict permit-to-purchase laws still exist, courts are reviewing whether the lengthy and subjective approval processes stand up under the Second Amendment's historical framework. Opponents of these permits argue that they transform a constitutional right into a privilege that depends on government approval, while supporters maintain that these extra steps are vital to screening out individuals who might slip through federal checks. The debate has intensified as recent court rulings have highlighted inconsistencies between states, with judges emphasizing that rights cannot vary so drastically depending on where one lives. This legal pressure has forced several legislatures to begin reviewing or revising their systems before they're struck down in higher courts. For gun owners, this battle matters deeply. If permit-to-purchase laws are overturned, it could dramatically simplify firearm ownership in several states, eliminating expensive fees and long delays that often frustrate first-time buyers. On the other hand, if these systems survive judicial review, they may become models for a new era of state-level regulation aimed at tightening gun control through administrative means rather than outright bans. Either way, the future of permit-based firearms schemes now hangs in the balance, as courts continue to test whether the power to buy a gun should ever depend on the permission of a local bureaucrat rather than the guarantees written in the Constitution itself. 6. Federal enforcement priorities, ATF/DOJ, have shifted. Inspections and revocations look different now. The landscape of gun law enforcement has changed dramatically as federal enforcement priorities under the ATF and Department of Justice have shifted, creating a new reality for gun dealers, collectors, and everyday firearm owners. For years, the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, operated under what many called a zero-tolerance policy, aggressively revoking federal firearms licenses, FFLs, for even small paperwork mistakes or minor record-keeping errors. This created tension and fear among licensed dealers who felt they were being punished for honest errors rather than willful violations. However, after heavy criticism from lawmakers, gun rights groups, and even some within law enforcement, the Department of Justice has revised that enforcement approach. In 2024 and 2025, the DOJ quietly began implementing a more balanced strategy, instructing ATF field offices to prioritize genuine bad actors, those involved in trafficking, illegal modifications, or intentional non-compliance, while reducing unnecessary revocations against responsible dealers who make minor clerical mistakes. This marks a clear shift toward what officials describe as a compliance-first approach instead of immediate punishment. At the same time, the DOJ has redirected resources toward targeting illegal gun trafficking networks, conversion device imports, and online ghost gun sales, viewing them as greater threats to public safety. For small gun shops and FFL holders, this change means inspections may now focus more on education and correction rather than enforcement and penalties. Many dealers report that recent ATF visits have felt less adversarial, with inspectors offering clearer guidance instead of looking for reasons to shut them down. Still, some gun rights advocates remain cautious, warning that federal agencies could revert to stricter interpretations under political pressure. For now, though, this policy shift represents a significant adjustment in tone, one that recognizes the difference between honest mistakes and criminal intent, while still maintaining oversight to prevent illegal firearm sales. In short, the federal government is signaling that it wants to focus less on punishing small businesses for paperwork errors and more on stopping guns from reaching the wrong hands, a move that could reshape the relationship between the ATF, gun dealers, and the American firearms community for years to come. 7. Sensitive places and carry restrictions are being relitigated. Don't assume old rules still apply. The issue of sensitive places and carry restrictions being relitigated has become one of the most critical and confusing aspects of gun ownership today, especially after the Supreme Court's recent rulings reshaping Second Amendment interpretations. Historically, federal and state laws have restricted carrying firearms in certain sensitive places, such as schools, government buildings, airports, and sometimes bars or places of worship. These restrictions were long considered settled law, and many gun owners assumed that as long as they avoided these designated areas, they were complying with all regulations. However, recent court decisions and ongoing litigation are challenging the scope and constitutionality of these restrictions. Some circuits are questioning whether the government can continue to prohibit carry in certain locations without providing historical precedent for such bans, as required under the Bruen framework. This has opened the door to legal challenges in multiple states, with some courts issuing injunctions or reinterpretations of what qualifies as a sensitive place, leaving gun owners in legal limbo. For instance, restrictions at city parks, restaurants, or public events are now being contested, and open or concealed carry bans that were once assumed lawful are facing renewed scrutiny. States like New York, California, and Massachusetts are actively defending their broad sensitive place lists, while gun rights groups argue that these restrictions often overreach and infringe on constitutionally protected rights. For gun owners, the practical effect is clear. You cannot assume the rules you followed yesterday still apply today. Carrying in areas that were once considered off-limits could now trigger legal disputes, depending on pending appeals and the interpretation of new precedents. This dynamic landscape means anyone who carries a firearm, even legally, must stay informed about current rulings, emergency injunctions, and local regulations, as failing to do so could result in criminal charges or administrative penalties. The ongoing relitigation highlights a broader trend. The boundaries of where you can lawfully carry a firearm are no longer fixed, and the legal map is being redrawn in real time, requiring vigilance and proactive awareness from every responsible gun owner. 8. Transactions, straw purchase definitions, and dealer record rules are being clarified. Paperwork matters now more than ever. The rules surrounding firearm transactions, straw purchase definitions, and dealer record keeping are now under unprecedented scrutiny, making paperwork and compliance more important than ever for both gun owners and licensed dealers. Recent court rulings and federal guidance have clarified that any attempt to circumvent the background check system, commonly referred to as a straw purchase, where someone buys a gun on behalf of another person who is prohibited from owning one, is being interpreted very strictly. The ATF has emphasized that even indirect involvement, such as helping someone fill out forms or knowingly transferring a firearm to a prohibited individual, can trigger serious criminal liability. At the same time, licensed dealers are receiving updated instructions on how to maintain accurate and complete records, with federal inspectors increasingly focusing on documentation rather than mere technical violations. For example, the chain of possession for each firearm must now be meticulously documented, including detailed records of all sales, transfers, and shipments, to ensure traceability and prevent unintentional violations. This shift comes as courts have upheld stricter enforcement in cases where incomplete or ambiguous records contributed to illegal firearm possession. Even casual buyers and collectors are affected, as private sales can be scrutinized under certain state laws if the transaction resembles a straw purchase. The guidance is clear. Paperwork is no longer a minor bureaucratic task, it is a critical element of legal compliance. Failure to accurately report transfers, or misunderstanding who is legally allowed to receive a firearm, can now lead to federal charges, revocation of dealer licenses, or long-term legal consequences for individuals. Gun owners and dealers alike must be diligent in documenting every sale and transfer, asking clear questions about the buyer's eligibility, and keeping records organized and accessible. The new emphasis on precision in paperwork reflects a broader trend of the federal government and courts taking a hard line against attempts to skirt the law, even inadvertently, signaling that knowledge, preparation, and meticulous record-keeping are essential components of responsible firearm ownership in today's legal environment. 9. Sentencing and administrative penalties for firearm offenses have been updated, effective this November. The stakes changed. The sentencing and administrative penalties for firearm offenses being updated, effective this November, represent one of the most significant changes in recent years for both gun owners and legal professionals. The U.S. Sentencing Commission, in coordination with federal guidelines and court rulings, has implemented new amendments that affect a wide range of firearm-related offenses, from illegal possession and unlicensed sales to modifications and the use of conversion devices. These updates alter both mandatory minimums and recommended sentencing ranges, meaning that violations which previously carried lighter consequences may now result in substantially harsher penalties. In addition to criminal sentences, administrative penalties for licensed dealers have also been revised, impacting everything from record-keeping violations to procedural non-compliance, with some fines and license revocation processes becoming more stringent. One of the key motivations behind these changes is to align enforcement with recent court rulings while also addressing emerging threats, such as ghost guns and untraceable firearms, which have become a focus for both ATF and prosecutors. Importantly, the new rules emphasize that ignorance of the law or minor paperwork mistakes may no longer provide a defense in certain cases, raising the stakes for anyone involved in firearm sales or transfers. For individual owners, this means that actions previously seen as low risk, such as lending a firearm or modifying a gun without full knowledge of technical definitions, could now carry serious consequences. For dealers, it underscores the critical importance of rigorous compliance, careful record-keeping, and proactive legal review. Overall, the November updates signal a shift toward stricter, more consequential enforcement and highlight how rapidly the legal landscape around firearms is evolving, making it essential for anyone in the firearms community to stay informed, review their practices, and understand how these changes may directly impact their rights and responsibilities. 10. The biggest change is procedural. Emergency orders and injunctions can flip legal reality overnight. The most dramatic and far-reaching shift in recent gun law developments is procedural. Emergency orders and injunctions can now flip legal reality almost overnight, creating an unprecedented level of uncertainty for gun owners, dealers, and states. Traditionally, changes to firearm laws required legislation, lengthy regulatory processes, or extended court appeals, giving people time to adapt. Today, however, courts are using emergency injunctions and temporary stays to immediately pause or reinstate laws, often in response to high-profile challenges following major Supreme Court decisions. This means that a regulation that appeared settled yesterday, such as a waiting period, permit requirement, or ammunition restriction, can suddenly be invalidated or reinstated with little notice, depending on a judge's ruling or an appellate panel's decision. For example, in some circuits, Emergency orders have temporarily blocked permit-to-purchase laws or paused red flag enforcement, only to be reversed days later by higher courts. The rapid pace of these procedural actions has created a legal patchwork, where the enforceability of specific gun laws varies not only by state, but also by federal circuit and even by county, forcing gun owners to stay constantly informed. Dealers, in particular, are under pressure to monitor real-time court developments to avoid accidentally violating a law that could suddenly be reinstated. This procedural volatility also affects strategic planning for advocacy groups and legislators, who must anticipate that any new law could be immediately challenged and temporarily nullified. While some see this as an opportunity to protect Second Amendment rights more quickly, others warn that the instability increases confusion, complicates compliance, and may inadvertently punish law-abiding citizens who are trying to follow the law. The takeaway is clear. In today's legal environment, gun owners and dealers must track court orders and emergency rulings in addition to statutes, because what is legal one day may become illegal the next, and staying informed has become as critical as following the law itself. This procedural shift represents perhaps the most profound change of all, highlighting how dynamic and unpredictable the current gun law landscape has become, and why vigilance is now an essential part of responsible firearm ownership. If you found this video helpful, hit like, subscribe, and comment below with which change surprised you the most. Stay informed and stay safe.